So good evening class. We will continue with Title 9 of the Revised Corporation Code of the Philippines. We will talk about merger and consolidation. So again, our source materials are Partnerships and Private Corporations by De Leon and De Leon Jr. as is applicable, and also the Revised Corporation Code of the Philippines, a short introduction by Aquino and Aquino. So anyway, before we dive into mergers and consolidations, let's talk about first yung forms of corporate combinations. So there are actually, I think, 5 forms of corporate combination. So the first one, sale of assets. So in sale of assets, remember, it is a union of corporations affected by one corporation selling all or substantially all of its assets to another. Usually, yung sale of all assets will lead to the dissolution of the vendor corporation, but not in all cases, of course. And remember, class, the mere sale of all property of a corporation and the distribution of its assets do not work a dissolution of the corporation, in as much as, remember, possession of property is not essential to corporate existence. Meaning, a corporation, even if it sells all of its assets, it can continue to survive. Anyway, hindi naman siya essential for corporate existence, yung possession ng corporate property. So, what else? Number 2, a lease of assets. A corporation, again, leases its property to another corporation. So, yung corporation nyo will become a lessor corporation. Tapos, yung isang corporation naman who leases the property is known as your lessee corporation. So, yung lessor, yung nagpa-upa, will receive rentals paid by the lessee, yung nangupahan. So, here, remember, what is leased are the assets of the lessor corporation. So, similar to sale, except that the ownership do not pass to the lessee corporation. What else in case of sale of stock? So, here, purpose of a holding company is to acquire a sufficient amount of stock or of another corporation for the purpose of control. So here, remember class, one corporation will buy shares of stock of another corporation. Yung kanyang purpose here is to buy a sufficient amount ng stocks for the purpose of control. So obviously here, you will have yung parent or holding company. Yung parent or holding company is the acquiring corporation or yung corporation who buys shares of stock in another corporation. Now, yung corporation na kung saan binili yung shares of stock or yung they will be called your subsidiary corporation. So, usually, a subsidiary corporation is controlled by the parent or holding corporation, because the parent or holding corporation is the majority stockholder in the subsidiary corporation. What else? A merger. Ito na yung ating topic talaga. 2 or more corporations unite, and one corporation will retain its corporate existence, and the other one will absorb or merge itself and then disappear as a separate corporation. So, here class, A corporation plus B corporation equals either A corporation or B corporation, depending on the agreement of the 2 corporations. So here, A corporation and B corporation are originally constituent corporations, ang tawag sa kanila. Later on, when they enter into a merger, A will become your, let us say, class, ang natira dito sa example natin is B corporation. A will become your merged or absorbed corporation, while B corporation will become the merging, absorbing, or surviving corporation. So in short, na-dissolve si A, namatay si A. B will survive and will continue its corporate existence. So obviously, the stockholders of A corporation will become the stockholders of B corporation. Here class, remember, yung merger will become effective upon the issuance of the SEC of a certificate of merger. What else? Number 5, consolidation. In consolidation, 2 or more corporations will unite and they will give rise to a new corporation. Remember, in consolidation, the constituent corporations will be dissolved and will cease to exist as separate corporations. So, in consolidation, remember, A corporation plus B corporation equals C corporation. Pareho silang na-dissolve. So, here, A and B will unite to form C corporation and they will transfer all their assets to C corporation. So, A and B are dissolved. Tapos, all of their rights will transfer, property and rights and liabilities also will be assumed by C corporation. Now, A corporation and B corporation will be known as your original corporations. Also, you can use the term constituent corporations. Later on, they will be known as your dissolved corporations kasi mawawala silang pareho. Now, C is a new corporation that is created by the dissolution of A and B. And also, C corporation is called the consolidated corporation. Obviously, the stockholders of A and B will become stockholders of C corporation. And the consolidation will become effective upon the issuance by the SEC of a certificate of consolidation. Now, the procedure for effecting merger or consolidation is number 1, kailangan mayroong plan of merger kung magme-merge yung mga corporations, or may plan of consolidation kung magko-consolidate sila. Obvious na yon. So, the board of directors of each constituent corporation will draw up and approve a plan of merger or consolidation. Gawa muna ng plan ng merger or plan ng consolidation as the case may be. Now, the plan of merger or consolidation approved by majority BOD or BOT of both the constituent corporations. Also, if there are dissenting stockholders, they may exercise their appraisal right, provided that if the plan to merge or to consolidate with another corporation is abandoned, yung appraisal right mawawala din. Anyway, we will discuss appraisal right when we go to Title 10. Huwag kayong magpanik. Kilala ko na kayo mapagpanik kayo class. So anyway, sa plan na yan, plan of merger or consolidation, there are specified items which you have to include. So number 1, the names of the corporations proposing to merge or consolidate, hereinafter referred to as constituent corporations. Sinabi ko na yan kanina. Ang tawag sa kanila, constituent corporations. What else? Number 2, the terms of the merger or consolidation and the mode of carrying the same into effect. Paano ba ang gagawin nila? That is number 2. Number 3, statement of the changes, if any, in the articles of incorporation of the surviving corporation in case of merger. Yung surviving corporation, siya yung natira. Remember, sa merger, isa lang ang na-dissolve. Yung isa will survive. So, there must be changes in the articles noong nag-survive. And in case of consolidation, all the statements required to be set forth in the articles of incorporation for corporations organized under the RCCP. Because the consolidated corporation is a new corporation, they have to follow the provisions of sections 13 and 14. Gagawa sila ng kanilang articles, gagawa sila ng kanilang bylaws. What else? Number 4, syempre, ito yung pinaka-importante, such other provisions with respect to the proposed merger or consolidation as are deemed necessary or desirable. Now, anong gagawin natin sa plan na yan kung tayo yung constituent corporations? Obviously, we will submit to the stockholders or members for approval yung plan of merger or consolidation. So, what to include there? Remember, class, these are separate meetings. iba yung meeting ng Corporation A, iba yung meeting ng Corporation B. So, separate corporate meetings with proper notice as always. Remember, proper notice here will include yung plan of merger or plan of consolidation, and dapat nakalagay sa agenda na ang purpose ng meeting is yung proposed merger or proposed consolidation. So, the notice of the meeting shall be given to all stockholders or members. Obviously, pwede rin namang makipag-merge and makipag-consolidate ang mga non-stock corporation. So, in the same manner as giving notice of regular meetings and special meetings. So, 21 days for a regular, 1 week for special. The notice shall state the purpose of the meeting, as I've said a while ago, and include a copy or summary of the plan of merger or consolidation. And pagdating sa meeting mismo, as scheduled in the notice, as nakalagay sa notice, remember, affirmative vote of the stockholders representing 2/3 of the outstanding capital stock or 2/3 of the members. What else after that? Remember, any amendment to the plan of merger or consolidation may be made, but again, if there is an amendment, it must be approved by majority BOD or majority BOT of both corporations, both constituent corporations, and ratified by 2/3 OCS or 2/3 of the members, again, of each constituent corporation. After that, the corporations will execute a formal contract. So, yung formal contract is known as your articles of merger or consolidation. So, here, articles of merger or of consolidation. So, depending on the case. So, it shall be executed by the corporate officers of each of the constituent corporations, to be signed by the president or vice president and certified by the secretary or assistant secretary of each corporation. So, meron na silang formal contract. Now, what are the contents of your articles of merger or consolidation? Number 1, ilagay dyan yung plan of merger or plan of consolidation. As to stock corporation, number of outstanding shares. In case of non-stock, number of members. Also, as to each corporation, remember the number of shares voting for and against the plan, respectively. Number 4, carrying amounts and fair values of the assets and liabilities of the respective companies as of the agreed cut-off date. What else? Method to be used in the merger or consolidation of accounts of the companies. Number 6, provisional or pro forma values as merged or consolidated using the accounting method. And again, very important, such other information as may be prescribed by the SEC. Now, pagka na-approve na yung inyong plan of merger, magda-draft na nga ng articles of merger or consolidation as the case may be. Now, anong gagawin dyan sa articles of merger or consolidation na yan? It will be submitted to the SEC for approval. So, articles of merger or of consolidation should be signed and certified and submitted to the SEC. Again, class, in case of corporations vested with public interest, kailangan ng favorable recommendation of the appropriate government agency attached to dun sa articles of merger or consolidation. Now, also take note that the SEC will require the resolutions of the respective boards of the constituent corporations, as well as the resolution of the stockholders or members approving the merger or consolidation. And this will be duly signed and attested by the respective president and secretaries, and it must state the reasons and causes for the merger or consolidation. Also, please take note of the accompanying documents to the articles of merger or consolidation. Ito yung mga kasamang documents doon sa articles. So, copies ng minutes of the board meeting of the directors or trustees, and also the minutes of the meeting of the stockholders or members doon sa ng constituent corporations wherein they approved or ratified the plan of merger or plan of consolidation certified by the secretary or the assistant secretary. What else? Number 2, kailangan din, in addition to the articles, there must be submitted also a list of creditors of the absorbed corporation as to the date of approval of the plan of merger, or in the case naman of consolidation, a list of creditors of the consolidating corporations or the constituent corporations. So, addresses and amounts owing to each creditor. So, what else do you have to include the audited financial statements of the constituent corporations, the date not earlier than 120 days prior to the filing of the articles with the SEC. What else? The amended articles of incorporation and bylaws in case of merger. Yung amended na ito, amended articles at saka bylaws ng surviving corporation. What else? In case naman of consolidation, syempre, articles of incorporation and bylaws of the new corporation will be submitted together with the articles of consolidation. Now, after submitting the articles and all of the accompanying documents, remember that the SEC will conduct a hearing, but only if it has reason to believe that the proposed merger or consolidation is contrary to or inconsistent with the provisions of the law. So it will set a hearing and give the corporation opportunity to be heard. So may due process ito. Written notice of the date, time, and place of hearing will be given to the constituent corporations at least 2 weeks before the said hearing. Pagkatapos ng hearing, SEC can proceed as provided for in the code. So remember, the SEC may or may not conduct a hearing. It depends. What else? After that, pagka okay na lahat, the SEC will issue a certificate of merger or of consolidation as the case may be, and that is the time that the merger or consolidation will become effective. So it will issue only if the merger or the consolidation is not inconsistent with the provision of the revised Corporation Code of the Philippines. So effectivity date, very important to determine when the merged or constituent corporations will cease to exist, and kailan mapapasa yung kanilang rights, privileges, and properties doon sa surviving or consolidated corporation. So obviously, the consent of the creditors, it is not required in case of merger or consolidation. How about in case of effects? So effects of merger or consolidation covered by Section 79, constituent corporations will become a single corporation. In merger, the single corporation referred to is the surviving corporation. In case naman of consolidation, the consolidated corporation. What else? Separate existence of the constituent corporations will cease. What else? Number 3, surviving or consolidated corporation shall possess all rights, privileges, immunities, and powers, and shall be subjected to all the duties and liabilities of a corporation organized under the revised code. What else? Surviving and consolidated corporation will also possess the rights, privileges, and immunities franchises of the constituent corporations, and also the property, real or personal, and all receivables due on any account. So, including subscriptions, etc., etc., and all interests belonging to the constituent corporation. So, lahat na yan ililipat sa surviving and consolidated corporation as the case may be. So, in number 3, lahat ng rights provided by law will be given to them. In number 4, lahat ng rights, privileges, etc. belonging to the constituent corporations will also be given to the surviving or consolidated corporation. And obviously, pagka may rights, meron din liability. Surviving or consolidated will be responsible and liable for all the liabilities and obligations of the constituent corporations. Yan. So anyway, that is it for merger or consolidate consolidation. Please stand by for Title 10, Appraisal Right. Thank you, class.